Hi guys, in previous lecture we have studied the previous topics and today we will study about the judgment of the Supreme Court case. So first paragraph is brief case of the facts. The court concluded that the plaintiff was injured while skiing, skiing at the Sky Resort Rudno Polji on 29 January 1992 and suffered transverse spiral fractures of both bones of the right leg at the time of the accident. The Sky Resort did not have an operating permit and use of the facility was intended only for use by members of the police and territorial defense forces. However, despite this fact, the defendant sold Sky tickets to other persons, including the plaintiff, since the operator allowed the public access to the Sky Resort. The courts correctly concluded that it was obligated to provide safety measures in accordance with the with then existing Act on Safety on Sky Slopes ZVJS. The courts found that plaintiff fell on the lower section of the Sky Resort at the edge of a small forest when where the snow was not compact. The court discovered that the plaintiff fell at a part of Sky Piste which was 2 m within snow that was not compact and about 5 mm above the compact snow. The claims of the plaintiff that he was acting correctly when she left the area where snow was not compact at the edges of the sky run on the route under the sky lift and nearby woods are irrelevant. Prior to falling, the plaintiff had been skiing outside the sky run and over snow that was not compact. However, the fall happened when the plaintiff was already skiing on the lower sky run. The defendant did not act in accordance with the provisions of ZVJS because the sky run had not been adequately prepared and because there was no science indicating this. In accordance with part number 1 of Art 9 ZVJS, sky run must be prepared in such a way that there are no dangerous parts. The defendant should at least have indicated by means of signs that the snow on the slope where the plaintiff fell was covered with snow by which had not been prepared in accordance with part 2 and 3 of Art 9 ZVJS. Because the defendant failed to fulfill this duty as demanded in Art number 9 ZVJS, the court correctly concluded that the operator was liable. Part 1 Art 154 in connection with Art 158 of the Code on Obligations. Where is the mouse? Judgment of the court. The courts correctly decided that the plaintiff contributed to her injury due to a violation of Part 2 of Art number 21 Act on Safety on Sky Slopes. He could have noticed patches of snow which were not compact because there were clearly visible on the sky run. Such patches of snow could also have been expected by the plaintiff as prior to the fall. She had been skiing on a higher run with areas of snow which had not been prepared. The fact that she was skiing at an unadjusted speed before the fall does not justify the conclusion that she is responsible for more than 40% of the damage incurred. Art number 192 in connection with Art number 205 of the Code on Obligations. Therefore, the court correctly decided that the defendant is liable to pay 60% of the compensation assessed for non-material damage. Upon examination of its own motion, the Supreme Court also found that the compensation for the plaintiff's non-material damage was correctly given by the lower courts in accordance with Art 200 and 203 of the Code on Obligation. So this is for today. I will uh, I will upload next lectures of that book in other videos. So keep in touch with our channel. This is for today. We will meet in the new video. Allah Hafiz.